on record? Yes. Counsel, one other thing I didn't bring up. I did do a quick jury verdict form. Yes, thank you. You can all be seated. My apologies. Take a look at that. Tell me if you want me to make any changes to it. We all have time to change it. Are we ready to bring the jury out, please? How many times can I do that on trial? I should probably change the setup up here.
Judge, is it okay or should I bother to explain our absence?
I wouldn't bother. I don't think they're going to notice. I didn't mean to disrespect by that, but I just don't. They're going to be paying attention to me, and I doubt they'll notice.
Please rise. Jury entering. Please be seated.
Thank you. Good afternoon, ladies and gentlemen. I hope you enjoyed your lunch. We are now ready to commence again. So, members of the jury, the evidence and the arguments in this case have been completed, and I will now instruct you as to the law that applies in this case. And after that, you will retire to decide your verdict. To reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you'll have to understand the definition of the crimes with which the defendant is charged, what to consider in deciding whether to believe a particular witness, and how convinced one way or the other you should be before you reach a verdict. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I'm about to give you. You must follow the law as I explain it to you, regardless of any opinion that you might have as to what the law ought to be. It is up to you to determine the facts in this case. You must decide this case solely on the evidence presented at trial and the law as I will explain it to you. You should reach a fair and just verdict without prejudice, without fear, and without sympathy. Now, the fact that the defendant has been arrested and charged is not evidence of guilt. The indictments are merely a way of giving the defendant notice of the charges against him. The indictments are a formal way of accusing the defendant of the crimes charged to bring him to trial. In your deliberations, you must not consider the defendant's arrest, the charges, or the fact that the defendant has been brought to trial as evidence of his guilt. The possible punishment the defendant might receive if you were to return a guilty verdict should not influence your decision. The duty of imposing sentence is for the judge. You should base your verdict only on the evidence and the law without considering any possible punishment. You have heard the lawyers discuss the facts in this case, and you've heard them discuss the law in their arguments to you. These arguments from counsel are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers stated the law differently from the law as I explain it to you, then you must follow my instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. During your deliberations, you should consider only the evidence presented at trial. The evidence consists of the testimony under oath of the witnesses, the exhibits that were admitted at trial, and what you saw on the view. You may not guess or speculate about evidence. You may only consider what has been introduced into evidence and the reasonable inferences that can be drawn from that evidence. And by reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. As I explained earlier, during the trial, the lawyers made objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or evidence would have been. If I ordered that a question and answer were to be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and allowed a witness to answer a question, you're not to give any such evidence any special importance because of my ruling. When I rule on an objection, I am merely applying the law as is my duty. If you believe that I suggested or expressed an opinion as to any facts in my rulings, you should ignore such opinion. The court in this case, as in all cases, is completely neutral and impartial. It is up to you alone to decide the facts of this case. Now, there are two different types of evidence. There's direct evidence and circumstantial evidence. Direct evidence is direct proof of a fact, such as testimony of a witness based upon personal knowledge. That is, what the witness saw, heard, or otherwise experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of some other facts. There's a simple example which I use to demonstrate the difference between direct and circumstantial evidence. Imagine that as you were sitting here, you looked outside the windows of this courtroom and you could see that it was raining. That would be direct evidence that it is, in fact, raining. Now assume that you were sitting in this courtroom and it didn't have windows, but that as you're sitting here, someone walks in the courtroom and they're wearing a raincoat and they're carrying an umbrella, and the umbrella and the raincoat are dripping wet. Now, you can't see outside, so you don't have any direct evidence that it's raining outside. But on those facts, as I've asked you to imagine them, it would be reasonable and logical for you to assume that it was in fact raining outside. That's all there is to circumstantial evidence. Based on reason and common sense, you infer from an established fact the existence or non-existence of some other fact. You should consider both types of evidence. There's no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You're permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it's direct or circumstantial. However, there is one rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of the charged offense, then to convict, you must find that the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if from the circumstantial evidence it's rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. Therefore, if there's a conflict between witnesses who offer direct evidence concerning certain facts, you should seek to resolve the conflict. For example, suppose that there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies the defendant did not commit the crime. That presents a situation where there's a conflict in direct evidence. And in that situation, you, the jury, should attempt to resolve the conflict and must decide whether, based upon all the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. So in summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that's important. What is important is the quality of the evidence. In deciding whether the state has proven a charge against the defendant beyond a reasonable doubt, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there's any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. In deciding which witnesses to believe, you should use your common sense and judgment. I suggest you consider a number of factors: the witness's appearance, attitude, and behavior on the stand, and the way the witness testified, whether the witness appeared to be candid, whether the witness appeared worthy of belief, the witness's opportunity and ability to see or hear the things about which the witness testified, whether the witness has an interest in the outcome of the case, the accuracy of the witness's memory, any bias of the witness or friendship or animosity the witness may have for or against any of the people in the case, whether the witness had any reason for not telling the truth, whether what the witness said seemed reasonable or probable, whether what the witness said seemed unreasonable or inconsistent with the other evidence in the case or with prior statements by the witness. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you're not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though their testimony is uncontradicted. Nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a large number. You can accept all of what a witness has said to you. You can reject all of what a witness has said to you. Or you can accept some of it and reject some of it. These principles apply to all witnesses, whether they are ordinary citizens, police officers, experts, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. Under our constitutions, all defendants in criminal cases are presumed to be innocent unless proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent person, and you must consider him to be an innocent person unless and until the state convinces you beyond a reasonable doubt that he is guilty of every element of the alleged offense. If, after all of the evidence and the arguments, you have a reasonable doubt as to the defendant having committed any one or more of the elements of the offense, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can be easily explained away. Rather, it is such a doubt based upon reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this: if you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the crime charged beyond a reasonable doubt, then you should find the defendant guilty. Now, the laws of New Hampshire set forth certain crimes, and each crime has a precise definition with at least two parts or elements. There's a mental state and there's an act. And in deciding whether a person is guilty of a crime, you must determine both what the person's actions were and what his mental state was. For a person to be guilty of a crime, he must have the requisite mental state and he must have physically acted to do something that is criminal. The word act refers to a physical deed. The word mental state refers to what a person mentally believes his physical act will accomplish. For a person to be guilty of a crime, he must have physically acted to do something that is criminal, and he must have had a particular state of mind. Unless a person both acted to do something that is criminal and had the required mental state, the person has not committed a crime. To understand how mental state works, consider this example. Suppose two different automobile drivers hit a pedestrian who was crossing the street. Suppose that one of those drivers hit that pedestrian deliberately. whereas the other one did so out of carelessness. The two drivers would be guilty of different crimes, even though they both committed the same act, because they had a different mental state. One did it purposefully, and the other did it carelessly. Those are the different mental states. The matter of determining a person's mental state is something that you will have to decide. There's often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and all the circumstances based on the evidence presented in the case in deciding whether the state has proven that the defendant had the requisite mental state and acted to do something that is criminal. All right, so now I'm going to explain the two different charged offenses in this case. So count number 1, and this is charge ID 2228154C. You don't need to remember that. But in count number 1, the defendant is charged with 1 count of attempted murder. The indictment alleges that on or about the 4th day of April 2024, Jason Levesque, acting with the purpose that the crime of homicide be committed, repeatedly shot Kyle Violette with a 9mm pistol, which, under the circumstances as he believed them to be, constituted a substantial step toward the commission of the crime of second-degree murder. So, in order to prove that the crime of attempted murder has been committed, the state must prove each part of the following definition beyond a reasonable doubt. So 1, that the defendant intended that the crime of murder be committed. That is, that the defendant acted with the purpose that the crime of murder be committed. Purposefully is defined further below. The crime of second-degree murder requires that a person causes the death of another. This means that the death of another person would have been the direct result of the defendant's actions. That was number 1. Number 2, the state must prove that the defendant took a substantial step toward the commission of the crime. The acts must be more than mere preparation to commit a crime. The acts must be a substantial step towards the commission of a crime. A substantial step means acts which strongly support the conclusion that the defendant intended to commit the crime of murder. Here, the state claims that the defendant committed the following acts. He shot Kyle Violette repeatedly with a 9mm handgun. It is up to you to decide whether this act constitutes a substantial step toward the commission of the crime of second-degree murder. Those are the elements of the crime of attempted murder. Certain words in that definition need to be further defined. The first is purposefully. Part of the definition of the crime is that the defendant acted with the purpose that the crime of murder be committed. This means that the state must prove that the defendant had the conscious object to cause Kyle Violette's death. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means the defendant desired to cause a certain result or to do the prohibited acts. It's not enough for the state to prove the defendant knew or was aware of what he was doing, nor is it enough for the state to prove the defendant created a risk of injury or harm. To prove that the defendant acted purposefully requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do particular acts. Now, at this point, I'm going to instruct you on self-defense, because evidence has been presented that the defendant acted in self-defense. When there is some evidence of self-defense, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. In deciding whether the defendant acted in self-defense, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. A person has the right to use deadly force on another person to defend himself or a third person if 3 conditions are met. 1, that he actually believed that the other person was about to use deadly force against him or the third person. In other words, the defendant could use deadly force if he actually believed that he or a third person was in imminent danger of death or serious bodily injury from the other person. Now, serious bodily injury, for purposes of understanding self-defense, means any harm to the body which causes severe permanent, protracted loss of, or impairment to the health or function of any part of the body. That is serious bodily injury. So a bump or a scratch or a bruise would not constitute serious bodily injury. As the words imply, serious bodily injury requires a serious or significant injury. So that was number one, that he actually believes that the other person was about to use deadly force against him. Number two is, even if the defendant actually believed that such danger existed, that is, that either he or some other person faced an imminent risk of death or serious bodily injury, that belief must have been reasonable. In other words, there must be reasonable grounds for the defendant to believe that the other person was about to use unlawful deadly force against him or a third person. Self-defense does not require an actual danger to the defendant. Rather, the defendant must reasonably believe that the other person was about to use unlawful deadly force. Third, the defendant must reasonably believe that the amount of force he used was necessary for self-defense. A person is not permitted to use excessive force in self-defense, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances as long as, at the time, there was reasonable grounds for his belief. So those are the three conditions that must be satisfied in order for self-defense to apply. I'll now move on to the second charge in this case, count number 2. In count number 2, the defendant is charged with one count of first-degree assault. The indictment alleges that on or about the 4th day of April 2024, Jason Levesque knowingly caused bodily injury to Kyle Violette by means of a deadly weapon, in that he shot Kyle Violette repeatedly with a 9mm handgun. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused bodily injury to another person, 2, the defendant did so knowingly, and 3, the defendant caused the injury by means of a deadly weapon. Those are the elements of the crime of first-degree assault. Several of the words in that definition require additional definition as well. First, bodily injury. Bodily injury means any harm to the body of another person. Knowingly. Part of the definition of the crime of first-degree assault is that the defendant acted knowingly. This means the state must prove that the defendant was aware that his acts would cause the prohibited result. The state does not have to prove the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware or knew that his conduct would cause the result. And third, deadly weapon. The term deadly weapon means any substance or thing which in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. And I will instruct you that a pistol or other firearm is a deadly weapon under New Hampshire law. I also remind you that for this second charge as well, some evidence has been presented that the defendant acted in self-defense. And as I explained before, when there is some evidence of self-defense, the state must prove beyond a reasonable doubt the defendant did not act in self-defense. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. And for further explanation of the law of self-defense, you can always refer back to the more full instructions I gave in count 1. Each of the indictments against the defendant constitutes a separate offense. You must consider each indictment separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the indictments should not influence your verdict with respect to the other indictments. Members of the jury, this case is important to both the state and the defendant. In your deliberations, you should follow these instructions which the court has given you. You should not decide this case out of bias or sympathy, but with honesty and understanding. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. That means your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so honestly and in good conscience. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purpose of returning a verdict. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to each of the charges before you. If you have a reasonable doubt as to whether the state has proven any one or more of the elements of the offenses charged, you must find the defendant not guilty. On the other hand, if you find that the state has proven all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. Now, because only 12 jurors will be deliberating, it is now time to select the alternates. And the alternates in this case are going to be jurors number 13 and 14 who are going to be assigned to be the alternates. As alternates, you will not be participating in the deliberations, but you still have an important role to play in that if one of the jurors were to be unable to continue, you would have to step in and deliberate in this case. So the alternates, you're going to have to remain in the courthouse until the case is decided. And you must continue to follow all of the rules which I have given for the conduct of jurors. One of the first tasks you will have once you go back into the jury room is to select a foreperson. The foreperson acts much like the chair of a committee. He or she should make sure that you take up the issues that I have described and should make sure that each juror has full opportunity to present his or her opinions and arguments. If any questions concerning the law should arise during your deliberations, the foreperson should write out the questions and hand them to the court officer. The officer will bring the question to me, and I will respond in writing as soon as I am able. I further instruct you that transcripts of the trial testimony of the witnesses are not available. In a few minutes, we will have copies of my instructions. You'll be given those. You'll be given the exhibits. They'll be brought into the deliberation room with you as well. Remember, I told you the firearm will not come back with you as an exhibit. If for some reason you decided you wanted to see the firearm to inspect it, we would have you come back in the courtroom and arrange that. We will also provide you with a laptop and the necessary software so that you can view the videos. You should take as much time as you like. When you have arrived at a verdict, let the court officer know, and you'll be returned to the courtroom where the foreperson will render the verdict orally in response to questions that the clerk of court will ask. I also will point out, in addition to the instructions that I'm going to have sent in with you, you'll be given a jury verdict form. It's very bare bones. It just lists the two different charges and has a checkbox for guilty or not guilty. So the foreperson will fill out this form and then tell the court officer that you have a verdict. Okay? Before I let you go, counsel, anything further we need to address before I let the jury go? Yes? Thank you. I think there are no further issues at this point, so we will have the jury brought back to the jury room where you can begin your deliberations. The two alternates, you'll be taken to a separate room. All right, thank you both all very much.
All rise. Jury departure.
counsel, I assume you've made arrangements with the clerk or the court staff to let us know, so
Oh,
we can
yeah,
get
I
in
was
touch with
told
you.
to do that.
So we can get in touch with you if we get a question or a verdict, if you're not going to be staying in the courtroom. Thank you both very much. Do you want to take these? Those are good?